Hello and welcome. I am Dr. Manvendra Kumar Tiwari and I'm an associate professor at the Dharmashastra National Law University, Jabalpur. Today we'll discuss in the legal reasoning part freedom of conscience and free profession, practice and propagation of religion as provided under the Constitution of India, which we popularly know as the right to profess and practice religion. However, the elements of conscience and profession are also associated with this right. As we can see, the provisions related to this right have been given under Article 25 of the Constitution of India. And it says, freedom of conscience and free profession, practice and propagation of religion, subject to public order, morality and health. So these are the exceptions. Subject to public order, morality and health, and to other provisions of this part, another exception. All persons are equally entitled to freedom of conscience and freely and the right freely to profess, practice, and propagate religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law. So the first part of Article 25 in Clause 1, though it is also subject to a lot many things, public order, morality, health, and all other provisions of Part 3, it guarantees to every person the freedom of conscience and the right to freely profess, practice, and propagate religion. However, again in Clause 2, it says that the rights provided to individuals under Clause 1 of Article 25 will not affect the operation of any existing law or prevent the state from making any law with a view to regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice, providing for social welfare and reform or the throwing open of Hindu religious institutions of public character to all classes and sections of Hindus. This is an important thing because this was instrumental in ensuring that the caste barriers when it comes to accessing the places of worship among the Hindu community does not result in isolating a section of the society from being able to access those places of worship based on their caste. So this is an important thing that a constitutional guarantee to this effect has been provided in the explicit terms in the Constitution itself. Then we have two explanations also. Explanation 1, the wearing and carrying of kirpan shall be deemed to be included in the profession of Sikh religion. And explanation 2 in the subclause B of clause 2, the reference to the Hindus shall be construed as including a reference to persons professing the Sikh, Jain or Buddhist religion, and the reference to Hindu religious institutions shall be construed accordingly. So this is mainly in respect of throwing open the institutions, religious institutions of public character. And it says Hindus here, the term Hindu here would include Sikh, Jain, Buddhist religions also. Moving ahead, we'll see a few passages to understand. The first passage that we'll see, the Indian Constitution uniquely prioritizes religious pluralism, toleration, and symmetrical treatment over a strict separation of church and state. A practice of principled toleration means one group must deem another different group's belief or practices wrong, mistaken, or undesirable, and yet put up with them nonetheless. Religious practices may seem strange, unnecessary, or unreasonable to non-adherents, and it is challenging for outsiders to judge a religion's value or evaluate its content. For this reason, many jurisdictions avoid evaluating the content of religious doctrine or making judgments about its correctness, value, or centrality. The Indian Supreme Court, however, remains a notable exception. Constitutional courts in India employ the essential religious practice, hereinafter ERP doctrine, which grants constitutional protection only to the religious practices which are essential to the religion. Now, this is important because Article 25 of the Constitution, apart from the exceptions that it contains, it guarantees to every person or religious institutions a right to profess and practice religion. Now, what the Indian Supreme Court has done is that it has limited the exercise of this right to freely profess and practice religion only to essential religious practices, in the sense that if there is an attempt by the legislature to actually restrict the right to profess and practice religion, then the court would examine whether the practice in question which the legislature has attempted to restrict is the one which is essential to the religion or not. And if it is essential to the religion, the court will go on to declare the legislation as unconstitutional on this ground. Now, this is peculiar because, first of all, the court would don the hat of a religious expert, and secondly, uh, it uh, it goes against the very spirit of the right to profess and practice religion. How, that we'll see. Indian courts seem to regard essentiality tests as positive inquiries, which do not call on courts to employ anything other than the ordinary tools of judicial fact finding, and can be resolved through resort to traditional evidence, such as reliance on expert witnesses, treatises, and factual testimony. However, over a time, a normative rationality requirement became part of the test, denying validity to practices which religious may have, which though religious may have sprung from merely superstitious beliefs and may in that sense be extraneous and unessential accretions to the religion itself. Some Supreme Court judges have recently indicated their strong dissatisfaction with the essential religious practice doctrine. A 9-judge bench capable of overruling even the weightiest precedents affirming the doctrine has been constituted to answer a spate of religious questions as well as inconsistencies in the prevailing religious jurisprudence. However, how might the court proceed? Recent judgments indicate that the court might adopt a more conventional approach that emphasizes deference to individual belief. These conventional approaches generally ask whether the religious practice in question is a sincere and plausible religious claim, and then weigh it against the state interest. However, it is doubtful whether existing adjudicative norms are up to challenge of judging sincerity and plausibility. For instance, the lack of petitioners with direct interest in the public interest litigations makes it challenging to evaluate sincerity. We'll come to the questions next, but what we need to understand is that the Indian Supreme Court, when it comes to determining the ambit of the protected right to freely profess and practice religion, has made religious practices that the court would find essential to the religion unsurmountable to any challenge. So this is problematic on two counts. One, that a religious practice, howsoever sinister, if it is proven to be an essential religious practice, then going by the jurisprudence evolved by the Supreme Court following the essential religious practice doctrine, no attempt to actually address those sinister religious practices, if proven essential, would actually succeed. So that is one aspect of it. And second aspect of it is that a person may have a very sincere religious belief about a practice that she might be following. Now, that innocuous religious practice, if not proven to be essential to the religion, now that innocuous religious practice held sincerely by a person belonging to a particular religious community can actually be declared as not part of the right to freely profess and practice religion. So this essential religious practice doctrine therefore cuts both ways. One, it gives a very long rope to what can be covered under the essential religious practice, but at the same time, it also in a way restricts the ambit of this practice by reducing the protection of right to profess and practice religion only to the practices which are essential to the religion. So moving ahead, the passage also tells us that in the recent past there has been some deviations where the courts have actually examined the extent, the sincerity of the belief held, and have not gone into the essential religious practice test, but that such adjudications remain on the periphery. And the passage is also highlighting the fact that this muddled reasoning has actually led the Supreme Court to constitute a 9-judge bench to answer all these inconsistencies when it comes to the jurisprudence of the right to profess and practice religion under the Constitution of India. It remains to be seen what will be the judgment of that 9-judge bench. Nevertheless, there is a hope that these inconsistencies will be taken care of. Another problem which the author, in this case, the author is Nihal Sahu and Shireen Muhammad from Indian Law Review. The problem that they are highlighting is the lack of petitioners with direct interest in public interest litigations, because this was one of the issues that actually originated from a recently passed order by the Supreme Court in Sabrimala case, where the public interest litigation was actually espoused by a group of lawyers who have got nothing to do with the Sabrimala temple and the women who have been restricted from offering prayers in the temple of Sabrimala. So therefore, a question has arisen whether a public interest litigation can be entertained when no one having a direct interest in is actually the petitioner challenging anything. And this is also one of the questions which the 9-judge bench constituted to answer these questions related to right to profess and practice religion would answer. Now we'll come to a few questions based on this passage. Freedom of conscience and the right freely to profess, practice, and propagate religion is subject to constitutional morality, public order, morality, and health. So clause D is the right answer. Freedom of conscience may or may not be associated with religion. Yes, because conscience may be different from religion. I told you in the beginning that though we understand this as the right to freely profess and practice religion, but conscience is also an important attribute of this right. The Indian Constitution uniquely prioritizes religious pluralism, toleration, and symmetrical treatment, and hence separation between church and the state. I think it's over a strict separation of church and the state. Indian uniquely prioritizes religious pluralism, toleration, and symmetrical treatment over a strict separation of church and state is the right answer. So option B. A practice of principled toleration means one group must deem another differing group's belief or practices wrong, mistaken, or undesirable, and yet they reject them. No, they accept them. No, they convert them into reason and desirable. No, they declare them as unconstitutional. I think they accept them. That's I was not correct when I initially said option B is also not correct, because we put up with those practices, howsoever undesirable we may think it to be, and that's why they accept them is the right answer. The Indian Supreme Court, however, remains a notable exception. Constitutional courts in India employ the essential religious practices doctrine, which grants constitutional protection only to religious practices which are central to the religion. It's just the substitution of a new word, central with essential. So I think option B is the right answer. Denying validity to practices which, though religious, may have sprung from merely superstitious belief and may in that sense be extraneous and unessential accretions to the religion itself is an empirical inquiry, a normative inquiry, a doctrinal inquiry, an epistemological inquiry, a normative inquiry. Though the court says that it is actually an empirical inquiry, but to say that a doctrine is not essential, this is a normative inquiry, and that is the problem with this proposition, essential religious practice test. Recent judgments indicate that the court might adopt a more conventional approach that emphasizes deference to individual belief. That is the new set of judgments that we have seen recently, where the essential religious practice test have not been gone into. So option B is the right answer. We will now come to a second passage as a part of this right to freely profess and practice religion. The sheer subjectivity of requiring judges to evaluate religious texts emerges from the decisions of the Kerala and Bombay High Court on the issue of headscarves in Muslim dress. In Fatima Saeed, the Bombay High Court rejected the claim of a Muslim girl challenging the direction of an all-girls school principal prohibiting wearing of headscarves. Meanwhile, in Amna Bashir, the Kerala High Court upheld the challenge by a Muslim female student to the dress code prescribing mandatory half sleeves for all candidates appearing in the All India Medical Entrance Test. The court took the view that wearing of headscarves and full sleeve dress is an essential part of Islam for women. In both Fatima Saeed and Amna Bashir, the judges had relied on the same verse from the Quran to arrive at diametrically opposite conclusions. In Fatima Saeed, the court adopted a reading that the Quran does not mandatorily require a girl studying in all-girls environment to wear the headscarf, whereas the Kerala High Court placed the wearing of headscarf and full-sleeve dress among the highest tier of obligation in Islam. The issue here is certainly not the correct interpretation of the Quranic verse, but rather the institutional competence to undertake the task. The absurdity of judges interpreting religious texts in the context of freedom of religion claims is typified by the decision of the Punjab and Haryana High Court in Gurleen Kaur case. The petitioners were denied the benefit of reservations set aside for Sikhs on the ground that they had not maintained Sikhi Swaroop, that is, Sikh appearance. Here the court analyzed various sources of religious interpretation in great depth and established that unshorn hair was an essential component of the Sikh religion, and the petitioners, by virtue of having shorn hair, could not claim the reservation set aside for Sikhs. It really is an incredible move by the court to use the EPD to determine the membership of a religious group. The court transforms a doctrine that was developed to restrict state interference in religious practices into a doctrine that will be used to determine the practices that need to be necessarily followed for the membership in a religious group. This is extraordinary, and such can be the implication of this essential religious practice test. This passage is from Anup Surendranath's article in the Journal of National Human Rights Commission titled Essential Religious Doctrine Towards an Inevitable Constitutional Burial. Now we'll see a few questions based on this passage. To evaluate religious texts is to invite subjectivity. Yes, that's the problem. Option B. On the issue of headscarf, the Bombay and Kerala High Court reached the opposite conclusions. B. Option B is the right answer. The institutional competence to undertake the task of interpreting religious text by the judiciary is the main concern. So option A is the right answer. In Gurleen Kaur, the petitioners were denied the benefit of reservations set aside for Sikhs on the ground that they had not maintained a Sikhi Swaroop. The use of EPD to determine the membership of a religious group was done in Gurleen Kaur's case. We just saw it. So this completes our discussion so far as the essential religious practice test as part of the right to freely profess and practice religion is concerned.